4 University of Idaho college students murdered by Bryan Kohberger, who has now agreed to a plea deal that would keep him from facing the death penalty. That would, the prosecutors say, keep the families from having to go over and over and over, days and days and days, into that courtroom for a trial. So here's what's happening right now. Top left of your screen, you are seeing Mr. Kohberger sitting there next to his attorneys. Forgive me, top right of your screen there, and then the judge down there at the bottom of the screen. Let's listen in to what the judge has to say.
So that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed, substantive questions, let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count 1, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
They have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, as to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include at trial video surveillance of a business on the Moscow-Pullman Highway just across the state line.
You're watching what is happening in a courtroom in Idaho right now, the Bryan Kohberger trial. Bryan Kohberger pleading guilty. You know, for all of these months, you've heard his name over and over and over, but today you also heard these names, his victims: Ethan Chapin, Xana Kernodle, Madison Mogan, and Kaylee Gonsalves. Young people, their whole lives ahead of them, brutally murdered in Idaho in the middle of the night. Each of them, somebody's family member. And some of those family members, bringing in criminal defense lawyer Danny Rubin to talk to us now on CBS News 24/7, are not happy about this plea agreement, this plea deal that takes the death penalty off the table. How does a plea deal come into play? And how is it the defense that brings it up, that wants it? Is it the prosecution, the prosecutor's office? How did this come about? And do you think that they could have proven this had trial started in August?
I think there's an ongoing dialogue between the prosecutor's office and the defense counsel throughout the process. The offer may have been given initially by the prosecutor or by the defense counsel. We won't know until the parties talk about it, if they ever do, because many of these settlement conversations are confidential. I think that there really was a lot on the table here with the death penalty. That's a big sticking factor for a lot of defendants looking at some serious time or looking at some serious penalties. And it forces them to come to the table and see what the strength of their defenses are based on the evidence and what the potential is that they lose. So it really depends, like I said, as to who initiated the conversation. It really just depends on the dialogue between the parties.
Bryan Kohberger, if the case had been successful against him, had it played out, gone to trial, and had he been found guilty by a jury of his peers, would have faced death by lethal injection in the state of Idaho. But in 2026, death by firing squad, that would have been his reality. Now, life in prison. How does this affect the case going forward? What's next?
Essentially, the next thing that's going to happen is sentencing. Really, the court has the opportunity to ratify any sort of plea agreement. As the judge said at the beginning of his commentary here, he does have the right to ignore a plea agreement. But generally, in the interest of justice, judges will not ignore those plea agreements if they believe it's in the best interest of the people, in this case, and in the best interest of the judicial economy, that they'll move the case forward. Here, Bryan Kohberger is facing a substantial amount of time in custody. He's facing consecutive life sentences, 10 years for burglary. You really can't get much higher than that except for the death penalty. The death penalty is also a political issue in many parts of the country. I'm sure that there are people who are contacting the judge, contacting the prosecutor's office, demanding for a higher penalty. But as far as the time is concerned, he really can't get much more than that. The judge really should be inclined to ratify this plea agreement. It certainly is fair for the people. Even if people are out literally demanding for blood, I think the judge is going to take judicial economy into the consideration, where this could be a weeks-long trial, followed by sentencing memoranda, followed by sentencing hearings, and most likely honor the plea.
So at sentencing hearings, after a trial and after a verdict has been leveled, we often see victims' families get to stand and give their own statements. In this case, will we likely see that, given the fact that we're now in plea deal territory?
Yes. Generally, when it comes to plea agreements and verdicts, plea agreements and sentencing, victims' families and victims do get a chance to speak out. In this case, the victims obviously can't speak for themselves. Their families will be speaking for them. They should and must be given an opportunity to speak. And that's prior to any sentence being given by the judge. I'm sure that there's going to be a lot of emotions in the courtroom this morning when the victims' families talk about lost loved ones. There are going to be some powerful moments, I'm sure. But like I said before, there are balances that the judge has to make with regard to what penalty is ultimately part of the sentence. And here, Bryan Kohberger really can't get much more time than what he's already agreed to. Consecutive life sentences with an additional 10 years added on for the burglary is a significant amount of time for this case. And I truly think that while the victim's family should have the opportunity to speak, and they will say some very powerful things today, I believe the judge will most likely ratify the sentencing agreement, the plea agreement.
Well, we know at least one of the victims' families have been very vocal about that plea deal. They want to see a different form of justice. Is there any way at all on the table that they can fight this series of guilty pleas?
There certainly is a way, if the judge is so moved by what they said to ignore interests of judicial economy, and to ignore the political issues that will result from a death penalty. I think he can say, I'm not going to go forward with this plea agreement, and essentially relegate the case back to trial. And essentially the proceedings will move on. The fact that he's already admitted to this will make that potentially a big problem for his defense. But like I said, if the process was such that plea agreements were not honored by the court in general, plea agreements would not be a useful tool in the defense counsel or prosecution counsel's arsenal. So while it is possible that the judge will overrule this plea agreement, it's very unlikely.
So you also heard the series of questions that the judge asked Mr. Kohberger leading up to those moments where he said, yes, guilty. The questions seem pretty pedestrian to a lot of us, but they are designed, are they not? For instance, did anybody give you any drugs or intimidate you or coerce you in any way? Those questions are very key to really shoring up the likelihood that Mr. Kohberger literally could not go back on this at any point in time in the future, correct?
It's exactly true. When you're issuing a plea, the court wants to make sure that there's no wiggle room here. That there's really no way to withdraw your plea on the basis of the fact that you were under the influence of drugs or mentally incompetent or did not understand the terms of your plea or the consequences of your plea. They want to make sure that you are locked in, that there's no wiggle room. And in this case, because Bryan Kohberger is giving up his right to appeal as part of the plea, that there's no room for appeal as well.
And it struck me when you hear the victims' names and the dollar figure assigned for restitution, what, $5,000 per victim? Is that dictated by the judge or is that dictated by statute? Because I would imagine anybody listening to that, you hear the names of somebody's child and then just $5,000 per name. That's got to give a lot of people pause if it doesn't make their heads explode.
Right, and restitution is not part of is not really a civil case. It's not part of a civil judgment. While it is relegated to a civil judgment upon the termination of really the sentencing hearing, the dollar amount is purely for financial issues, lost wages, funeral expenses, etc. Where the family is probably going to go next is to file a civil claim against Bryan Kohberger for losses related to loss of life, loss of familial relationships, pain and suffering. All those things are civil cases and belong in civil court. With regard to restitution, it's purely for financial issues. So even though the dollar amount is low, the amount that you're allowed by statute, or the categories of costs that you're allowed to collect in restitution by statute are limited.
Danny Rubin, thank you for that. Let's continue listening in to this hearing.
Was found on the knife sheath that was next to Madison Mogan's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court and the public the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you, Your Honor.
Thank you. All right, based on the state's proffer and importantly based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first-degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first-degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes.
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the
And so
victims
there you
have the
have it,
opportunity
what brings to an end the story of the 4 of the most brutal murders we've covered in so many years here at CBS News, that of 4 college students in Idaho. Bryan Kohberger saying before a judge and before the entire world, he did it. What we are not
victims
hearing
will be given
is
an
a why.
opportunity to,
We could
provide,
hear in the
the
coming
statements that
days,
they wish
weeks,
to
months
at
ahead
sentencing.
why he did it.
Do we
But
need
for
more
now,
than
the
1 full
families
day
of
for
those 4
sentencing?
young college students know he said he
I
did
do
it.
not believe
He's
so,
spending the
Your
rest of
Honor.
his life
I
in
believe-
prison.
obviously
CBS News
we
with
have
Meg Oliver next.
numerous